I'm Susan Aronson, and I'm here in Arlington, Virginia. And I'd like to welcome everybody to this webinar, which will focus on the US-UK potential digital trade chapter and other ideas related to digital trade. We are so lucky to have three experts with three very different perspectives on these issues. And so I'd like to welcome Sabina Ciofu from techUK, Sam duPont from the German Marshall Fund, and Nigel Cory from the International Technology and Innovation Foundation. Okay, I blew that. But, so Nigel, correct me.
The Information Technology and Innovation Foundation.
Thank you so much. And you can see their bios in the invitation and link to their publications. So with no further ado, we're gonna begin. And we will touch on SHREMS too, given the timeliness of it. So welcome everybody. And what I'd like to invite everybody in our audience to do is to write questions in the Q&A. And I'll begin with a couple of questions and then we'll move on to your questions. So we're gonna begin with Sabina. Can you talk about the UK expectations for this free trade agreement related to digital trade?
Sure. Hi, everyone. Really nice to be here. And I'm sure we'll have a pretty interesting conversation given the news of today. I'll kind of push that can a bit down the road. So I'll start by talking a bit about what the UK is likely to look for in a digital trade chapter in trade agreements, kind of broadly, not just with the US. We only have, for the moment, a UK legal text in the proposal to the EU. But as far as we understand from the Department of International Trade, that's likely to be a sample for how they intend to approach digital trade in trade agreements more broadly, so with the US included. So I'll just go through a bit of the provisions that we've seen in that proposal and how they match or don't with what we have in other kind of trade agreements, regional or bilateral so far. So there is a lot of stuff in there that's based on existing trade agreements. So whether we look at USMCA, in CPTPP, or even like the more recent DPA, there are kind of points that you'll see in pretty much all of these trade agreements. So elements on no tariffs on electronic transmissions, including like transmitted content, no prior authorization for the provision of services. There's elements in there on e-contracts, e-authentication, e-signatures. Also a lot of bits and pieces that we've seen in DPA under Business and Consumer Trust module, which relate to kind of online consumer protection, unsolicited commercial electronic messages, and kind of open internet access. So a lot of these elements are kind of common across a bunch of different trade agreements, and the UK seems to sign up to these provisions from what we've seen so far. And there are also elements on, you know, the protection of source code and algorithms and encryption keys. And most importantly, I think for as a kind of direction, if you want, that we've seen from the UK government so far, they really have provisions on emerging technologies dialogue, on regulatory cooperations on digital trade, and kind of setting up with the EU an actual committee on digital trade to look at these issues. So, you know, broadly, what we have is pretty common across a number of trade agreements that have good digital trade chapter for business. So, so that's definitely something that we welcome, and our members have been vocally supportive of it so far. What we are missing is cybersecurity cooperation, but that's for the pure reason that that's being negotiated in a separate agreement on security and judicial cooperation in between the UK and the EU. There are no provisions on digital ID, for instance, or on digital inclusions that we've seen in DPA, for instance. And surprisingly, so far, but you know, we think the UK government is likely to hold on to that commitment. There are no provisions on the protection of intermediary liability. But from what we heard so far from the UK government, is likely to stick to the e-commerce directive and the protections for intermediary liability in there, even as it looks to kind of regulate, online harms and other things. So that's broadly what's happening. Now, of course, I've kind of left the elephant in the room last. So we would like to see, data flows provisions, of course, in the UK-US trade agreement. The UK government would like to see data flows provisions in that agreement. That just became a lot more complicated this morning with the ruling from the European Court of Justice. So just to give you a bit of context, the UK data flows, 75% of them are with the European Union. So a big priority for the UK is getting a positive adequacy decision from the EU to be able to transfer data with the EU. Now, that doesn't mean that you can't have data flows provisions with other partners around the world in your trade agreements, or it didn't until this morning. So the European Court of Justice validated the mechanism of standard contractual clauses. So it kind of said they're valid, but it left it up to the data protection authorities to analyze just how valid they are on a case-by-case basis, which, as we've kind of seen in the GDPR review, that's, these DPAs are mostly underfunded and under-resourced, so they just got a new job that they'll have to deal with. So that's one thing, which is a bit of a sigh of relief, but with the bracketed condition that, we don't really know how DPAs will analyze all these cases, and it's not a blanket validation of the mechanism. But the more urgent matter is that they struck down the privacy shield, which is the partial adequacy agreement that the US had with the EU. And that would have been a mechanism that the UK would have just signed up on after the transition period. So the privacy shield would have been an agreement between the UK, the EU, and the US, the EU, and the UK. So that would have been the kind of owner transfer mechanism that would have allowed the UK to have data flows provisions with the US, while also having an adequacy decision with the EU. Now, in this current context, we'll have a negotiation going on between the Commission and the US, so on how to kind of discuss and solve the issues raised by the ruling today that the UK will not be part of. And then, there will be significant consequences of how the UK negotiates this trade agreement with the US in the same time as the EU. There will be potential consequences for the actual adequacy decision for the UK, given the concerns that the European Court of Justice raised. So yeah, I think it raises more questions than answers, but it's not my fault, it's the court. So I leave it there.
Okay, thank you for that, Sabina. Sam, can you talk about the US template now in light of this decision and where you think it's going?
Sure. And thanks, Susan, for having me this morning. Thanks, everyone, for joining. So with regards to the template that the US will use for the US-UK negotiations, I think it's a fairly safe assumption that the USMCA text on digital trade and as well as other areas will be the basis for what the US comes to the table with vis-a-vis the UK. So the USMCA digital trade chapter includes rules on data flows and data localization, and those rules are each a sort of step further, a step more, a step stronger from what the US had negotiated in its previous agreements. And while I think the delta between what the UK has put forward vis-a-vis the EU and what the US is likely to put forward is modest, I think there will be negotiation to be done there. The US, again, will come forward with, I think, very similar, if not identical, rules related to digital products and the application of customs duties to electronic transmissions or digital products. These kinds of rules, or the digital product, non-discrimination on digital product rules, were not included in the UK's proposal to the EU. So again, I think there will be a need for a negotiation there. Likewise, on source code and algorithms, another priority for the United States and for US business, I think safe to expect something similar to what we saw in USMCA. One very interesting question is how the US will approach the intermediary liability issue. In USMCA, of course, there was a provision on interactive computer services that mirrored Section 230 of the Communications Decency Act in the United States, which provides liability protection for online platforms and other intermediaries. And that provision and the conclusion of that provision has been a source of controversy since the conclusion of that agreement. The political landscape around Section 230 has changed a lot since 2018. There is a lot more skepticism in Congress than there used to be. Several members of Congress, including, as if I'm recalling correctly, Speaker Pelosi, raised objections to the inclusion of this rule in USMCA after the negotiation was concluded and when the implementing legislation was well on its way in Congress already. So in that case, it was sort of too late for Congress to really meaningfully change this kind of provision. But I think it's an open question as to whether Congress would again look favorably on another agreement that included a provision like this. So I would assume that the U.S. would come forward with a proposal that again mirrors USMCA, but how that is dealt with through the course of negotiation, I think, is an open question. And then I think there's opportunity for innovation in the kinds of proposals that the U.S. puts forward. If you look at the trade agreements that the U.S. has concluded in the past, you can see a steady evolution in both the range of proposals that the U.S. has agreed, as well as the specific text of each provision. And I think you can expect to continue to see that kind of step-by-step evolution in the U.S.'s digital trade priorities. So, for example, in past agreements, the cybersecurity provisions have been limited to cooperation. I don't know exactly what direction the U.S. is likely to take that, but I think there is opportunity for stronger, more binding provisions in the cybersecurity space. Likewise, artificial intelligence was much less of a policy priority the last time the U.S. was negotiating on digital trade and an FTA. Many of the concerns of AI service suppliers are addressed through source code provisions or through data flow provisions, but there may well be other rules that the U.S. could put forward that would help advance the AI services between the U.S. and the U.K. So I think that's sort of the template that I would expect and the opportunities for changes and evolution. It's hard to know exactly how the ECJ's decision this morning on the Schrems 2 case will impact the US-UK negotiations. I think it's one obvious result is that it makes the US and UK negotiations even more important, I think, for both sides, and heightens the urgency of concluding high standard, meaningful rules on digital trade, both for the US and the UK, both of whom I think are in serious jeopardy as a result of the ECJ's decision. I think the decision creates an awful lot of uncertainty for any service suppliers that depend on the ability to move data across borders. And while the decision directly impacts Privacy Shield and US firms, the thousands of US firms that are registered under Privacy Shield, it's safe to assume there will be knock-on effects for British firms that depend on the ability to export data across the channel. So I'll stop there for now. I think there's a lot more to talk about on all these issues, but hopefully that suffices as an opening comment.
That's great. Thank you, Sam. Nigel, can you give a scholarly perspective on all of this, looking at the UK perspective, looking at the US perspective in light of your expertise on other countries?
Sure. Firstly, thanks for having me, Susan. It's great to be here with Sabina and Sam talking about issues I love working on. I think, firstly, I mean, it's pretty amazing. It will be really interesting to see how the ECJ's decision on SREMS will flow on, because it could really wreak some havoc on global data flows. And it comes at an extraordinary point. It comes at an extraordinary point in time during a global pandemic, when global data flows are more vital than ever, and not only puts at risk global data flows from the EU to the US, but with pretty much every other country. And so that creates an enormous amount of uncertainty about how it will sort of flow on and be applied, and sort of obviously indirectly and directly sort of impacts the issues we're talking about, and how they'll be addressed between whether it's the UK and US, or between Australia, Singapore, New Zealand and others that are currently dealing with these data and digital and related issues. First issue that comes to mind, especially in the UK-US context, is how this would affect not only the UK's management of data flows with the EU, but also how does it aim then to manage onward transfer of EU data to the US, and what mechanism and what specific details or rules it could expect to try and use to try and manage that, so that essentially it can have the best of both worlds in terms of maintaining access to the EU market while still allowing its firms to operate internationally in how they use that data. But I think, I suppose what it also shows is it just presents a very contrasting EU-centric approach to the management of data and data privacy in global trade vis-a-vis approaches that other countries are using in the Asia Pacific. And this is where I'm referring to, Sabina mentioned it, the digital economy of partnership agreements between Australia and Singapore, and between Singapore, New Zealand and Chile, which involve both explicit rules and cooperative mechanisms through MOUs. And I think these MOUs and digital economy agreements reflect the fact that the digital economy is the future, and that these countries recognise it. That the internet means these digital technologies like AI create interdependencies between markets and regulatory regimes that require sort of coordination and cooperation from a far earlier stage in their domestic rulemaking process if they want to truly create an innovation and trade-friendly framework for the future. These MOUs cover cooperation on AI, electronic invoices, cross-border data flows, personal data protection, digital identity and other issues. Now, MOUs are a dime a dozen in economic statecraft. The only thing that makes them valuable is if parties operationalise them in ways that both sides find beneficial. And I think this is clearly possible between small groups of highly motivated, ambitious and like-minded trading partners. And I think these agreements and MOUs reflect a recognition that the best approach to these issues is not yet set in stone, but that international cooperation is needed from the start, and that domestic and international processes can work in tandem, and that it's important to consider the international impact of these key enabling domestic regulations shouldn't be left as an afterthought for years after they come into effect, as it has in Europe with GDPR, because then it just becomes much harder to build an open, rules-based, interoperable global digital economy. And I think Australia, Chile, New Zealand, Singapore, and I highly suspect the United Kingdom are proactively pursuing this type of international cooperation on digital technologies in and alongside trade agreements, as explicit new digital trade rules, as needed and as important as they are not enough to support modern trade and innovation. These MOUs obviously shouldn't be seen in isolation, and that they're really only an international extension of these countries' domestic efforts to support the development and deployment of digital technologies, such as, for example, Singapore's use of regulatory sandboxes for fintech, and there's a whole host of other policies that fall into this bucket. And so I think it really shouldn't be surprised that these ambitious, highly motivated countries are seeking to use these MOUs to build clearer, rules-based digital market access. And for these countries, I think it directly refutes the completely misguided, mistaken perspective that digital trade is something that only Silicon Valley and the United States cares about, in that new digital trade rules matter much more for small and medium-sized countries, as they simply don't have the internal economies of scale, and obviously don't have the ability to force other major markets to open their digital economies, especially in regards to China. And so I think this approach reflects a recognition that there needs to be a complementary sort of effort alongside explicit hard rules that involves cooperation and coordination on rule settings and regulations, and on the identification and use of international standards from a much earlier process, if they want to ensure that the trade agreements essentially are future-proofed, in that we don't find that in 5 years' time, with technology changing in a way that we can't yet predict, somehow doesn't sort of fit the framework that they've got there, that there's some flexibility built into that. And so I think the UK certainly seems to sort of be paying a lot of attention to the approach in DEPA and in these MOUs, as well as some very similar components that are part of USMCA, in trying to figure out how it puts those pieces together itself to create sort of this digital trade framework that it's really sort of set out as a priority for its sort of post-Brexit sort of ambitions.
Thank you, Nigel. I just want to highlight a point that you made, which is the 2 points that you made. You said that that digital trade is not just an issue for industrialized countries or wealthy countries. And you also said essentially that the leaders of this are small open economies that don't have economies of scale and scope for data. And I wanted to give an opportunity for Sabina and Sam to comment about if you agree, and then what next then? If you know, the United States has a model that might not work with this more open, accommodative model. I just want to hear what you think. So, Sabina, you want to go first?
Sure. I think I had a bit of a connection problem, so do you mind kind of repeating the first part of your question? I only got the Sam question.
Okay, so so Nigel made 2 important points. I'll let him make them again.
Basically, that digital trade rules matter even more for small and medium-sized economies because they don't have economies of scale. And so rules are more important.
And scope for data.
And scope for data. And then how does that sort of contrast with, I suppose, US digital trade policy as it's currently defined, and what do both of those, how do those issues play into UK considerations for the future?
Yeah, sure. Thanks for repeating that. Yes, so I think that to a certain extent explains the direction that the UK has been taken in its trade policy so far, and what we've seen in terms of, you know, wanting to do bilateral agreements pretty quickly with a number of countries, while also negotiating with the EU, but also wanting to join CPTPP, and separately something we've kind of had conversations with the UK government on, and kind of supported as an idea, is for the UK to join DEPA as well, which we think is very much in line. So everything we've kind of seen on DEPA and everything we've seen in the UK proposal in the EU agreement are pretty much in line in terms of, you know, what do they want to achieve. And there seems to be a focus for the UK on the Asia-Pacific region, if you look at who they are negotiating with at the moment and how they see their kind of trade policy moving forward. So I definitely think that the UK kind of sees this as an opportunity. And we agree, there is a massive opportunity, especially on digital trade, by leaving the European Union and being able to kind of negotiate digital trade chapters and redraw a bit the lines around how you do data flows in your own trade agreements, as maybe opposed to what the EU has been able to achieve so far. So, so definitely it is a matter of the UK looking kind of broader around the world. Who are the like-minded countries? Where can they find partners to develop and kind of agree on progressive digital trade standards? And yeah, we are very supportive of that approach, and especially looking at the digital economy partnership agreements, and kind of the more, which we, you know, when we were talking about 6 months ago, they were kind of in the process of being made and agreed. Now we actually have them on the table, and you can actually join them, which we think we should. Susan, I think you're on mute.
Yeah,
muted.
I just
think you were
realized
calling.
that. Well, Sam is going to go next, but again, we encourage you to ask these experts questions. We're here for you. Go ahead, Sam.
Yeah, no, I fully agree with the points that Nigel and Sabina just made. I mean, it's absolutely true that smaller economies are benefit more and are more dependent on digital trade rules than the large economies, and that's not specific to digital trade. That's true of trade in general. You know, there are no bigger cheerleaders of the WTO than the small economies that depend on trade for their economic survival. And so I think it's true that certainly in Europe and elsewhere in the world, the push for binding rules on data localization and cross-border data flows, and the push for binding rules on issues like source code has been perceived as the agenda of the GAFAs, of the big US tech companies. And I think that it's just a misread of the way that the global economy is working today. You know, increasingly the concept of a digital economy is sort of irrelevant. Every piece of the economy is digital, and so the digital economy really just is the economy. Likewise, digital trade is just trade, and it's hard to imagine a piece of international trade that isn't affected by digital technology. And so I think it's a very good point, and one that needs to be repeated. That these rules are not they're not for the exclusive benefit or even the primary benefit of big U.S. corporations. They are essential for any country that wants to take meaningful part in the 21st century economy. On the second point about these kinds of less binding, more cooperative measures, I think it's exactly right. And I think that was the great achievement of DIPA, the Singapore, New Zealand, Chile agreement. That agreement, in certain respects, only repeats what has been achieved by those countries in their prior FTAs. And in the areas that aren't addressed by their prior FTAs, most of the rules or measures that are included are of a cooperative, soft nature. There are requirements to cooperate. There are commitments to endeavor to implement certain provisions. There are statements of principles for how certain aspects of the digital economy should be organized. And those kinds of rules have typically been left out of FTAs. They certainly don't show up in the past. They're not the focus of US FTAs that we've seen in the past. But I think if you look at the US-EU digital trade relationship, the history of the past 10 or 15 years is a very good case study in why these kinds of cooperative measures are important. You know, looking at privacy, 10 or 15 years ago, the US went one way on privacy, Europe went another way on privacy, and here we are today with the divergent privacy regimes creating huge commercial and trade challenges and interoperability challenges between the US and EU economies. Looking ahead, there's going to be an awful lot more technological innovation in the years to come in AI and all sorts of other emerging technologies. And both the US and the EU are starting to think about how to regulate these kinds of tools. If again, we see the two sides of the Atlantic taking divergent approaches to governing and regulating these emerging technologies, it's going to create more and bigger trade and commercial barriers between the two economies. So I think that's a very good case study in why these kinds of cooperative mechanisms are important, because they provide an early opportunity for different economies to point themselves in the same direction. The point isn't that everybody needs to regulate the economy in exactly the same way, and that's not shouldn't be the objective of a trade agreement, and isn't realistic anyway. But the point is to point in a similar direction, such that down the road, firms can operate across borders. You can have interoperable solutions that can address multiple markets, and differences in regulation should not and ultimately don't create trade and commercial barriers.
Thank you all for those thoughtful comments. I have a quick question just to ask you, all of you, if the US were to ban TikTok, what would that do to US leadership of the open internet if the United States truly does lead that? And Sam, if you could provide some insight, does USTR have a voice in that decision? You know, looking at trade issues?
Let Sam, you go first, and then I'll happy to weigh in on the TikTok thing.
Sure. I mean, I think any decision like this, if it's a decision taken by the executive branch, it'll be taken with all agencies participating in the decision. And so USTR and the trade interests of the US, I think would certainly be taken into account, including the potential implications for US trade commitments at the WTO. I think we don't know exactly what the executive branch is considering. We know that Congress is thinking about a few different ways of disciplining concerns about TikTok, including prohibiting the installation of the app on government-owned devices, which strikes me as reasonable and may well address part of the concern. I think the sort of range of other possibilities include measures to address the security and privacy of data. In that respect, I'm not sure TikTok is any different from another Chinese-owned or foreign-owned app, and probably the solution for TikTok is going to be the same solution that we would want to see with regards to other apps and other software services. So in that respect, a strong privacy law that includes measures for the protection of personal data would presumably be the right way to address data privacy and data security concerns with regards to TikTok.
Nigel, jump in.
Yeah,
thank you.
Yeah, so I think depending on how the US reacts to TikTok will be critically important to the US role in leading and setting rules around an open digital economy in the future, in that it needs to react and address specific concerns about TikTok, which are not unique to TikTok in terms of its use and application. I think the problem with a broad ban is if it's done on unspecified national security grounds, then it really sets a precedent that other countries could just as easily apply to US, European, UK, any firm they like, without sort of the need to provide clear evidence that it's contravening a specific sort of national security issue. So I think Sam's point on a strong domestic data privacy regime gets at some concerns of that. It also ties into the underlying concern about the Schrems case in terms of the need for countries to do much more work about clarifying the rules around government access to data, because that's the boogeyman that's often sort of used in the background around TikTok in terms of the Chinese Communist Party's relationship with private firms, and if there are any limits to its ability to access data. That's a legitimate concern, but focus on that. And because the firm being used by consumers is largely irrelevant, because this same issue could be happening with any other service that's on your smartphone. And so that just highlights the fact that the European Union, the United States and others who are rule of law countries, which have their own approaches to data privacy, obviously have their own national security interests, working together to set guardrails around how they each approach the legitimate ways in which they need access to data for law enforcement or national security.
To me, that's saying they need to narrow the exceptions. But okay, so let's start with a question to Sabina, and that is, how will the UK prioritize data flow agreements with the EU versus the United States?
Yes, that is the million-dollar question, isn't it? There was a lot of discussion, if you remember, in the beginning of the whole, this year after the UK left the European Union on the 31st of January, and whether there will be a sequencing of the trade agreement negotiations, and whether there will be a kind of agreement with the EU first, and afterwards a negotiation with US, Japan, Australia, New Zealand, and so on. In the meantime, the UK has made it clear that it will negotiate with all these partners in the same time. So we don't really have an actual sequencing of the negotiating process. However, there is an actual deadline for the EU negotiation, and that's the end of the year. And it seems to be a slightly more open-ended negotiation with the US. So the hard deadlines here are with the EU and with Japan, because the Japan EU agreement kind of ends at the end of the year as well, unless it's transposed into something else or just transposed into what it is, but for UK, Japan. So those are hard deadlines. Now, of course, politically, there may be a deadline here as well when it comes to kind of the US election in November. So that does pose some questions on who do you agree with first, and what kind of provisions you agree on. Now, as I mentioned in the beginning, a lot of the data flows that the UK has are with the European Union. So an adequacy decision is a massive priority for the UK tech sector. Getting that right, and then figuring out what you can do within the limits of that adequacy decision in your other trade agreements with the rest of the world is probably the kind of more sensible way to go to avoid, kind of massive disruption at the end of the year. So we would kind of like to see that bit of sequencing there. Now, the ruling this morning means that, that ruling is binding in the UK for the rest of the transition period. So it's automatically, there is no onward transfer mechanism currently legal for the UK to be able to put that in a trade agreement to say, okay, we have data flow with the US under the privacy shields and an adequacy of the EU. So that kind of creates a lot of questions for the UK government as it designs its own international data transfer mechanism, which is kind of going on in parallel. It's a parallel kind of domestic consideration there, where basically the UK is also considering how it's going to do its own transfer mechanisms after Brexit. And it seems to be based very much on the EU model. So it seems to be based on an adequacy model. They will basically start analyzing other countries, well, transfer the already existing adequacy agreements, but basically analyze other countries on its own kind of adequacy system. So it seems to kind of carry on with an EU model, at least for the time being. We'll see how that develops. I think they're keen to kind of see potential tweaks to the data protection framework and the data flows framework moving forward. That would kind of make business easier and data flows easier. But for the time being, I think we are likely to see, at least in the short term, a very much EU-based kind of approach to data flows. So yes, I'm not sure that actually answers your question, but it's just a lot of kind of moving pieces at the moment, and a lot of kind of, except for the hard deadlines that we know about, there is also a question of whether we actually get a mini deal with the US, and that's something that can be done in a few months and kind of, approved without Congress, or, is it that the UK is actually going to do what it says, which is a free trade agreement, and kind of take its time, as it were, with this negotiation, and give it all the time it needs to reach a comprehensive agreement. There are all this kind of multiple questions going on, but definitely massive priority is getting the adequacy of the EU.
Okay, thank you. Here's a question starting with Sam. Do you see de facto non or under taxation of big tech as a digital trade issue?
It's a good question. I mean, the interplay between trade and tax I think will be an issue that we will all be thinking a lot about in the coming years. Historically speaking, trade agreements haven't dealt directly with taxation issues. And I think we have maybe begun to see a little bit of a transformation in the way that the Trump administration has responded to certain digital service taxes that have been implemented or proposed around the world, in that to look particularly at the French digital services tax. So when that was unveiled a couple years ago, the USTR undertook an investigation of that tax and ultimately found that it was discriminatory and violated basic trade principles of fairness and non-discrimination. And so on that basis, the administration has imposed but not yet collected on tariffs on certain French goods. So in that respect, it is the investigation and the retaliation by the Trump administration's USTR is effectively treating the discriminatory nature of this tax law as a trade issue. More recently, the USTR has undertaken similar investigations with respect to, I think, 8 or 9 other countries, including the UK, which is in the relatively advanced stages of implementing its own digital services tax. I think whether each one of these taxes is found to be discriminatory and found to be a violation of trade commitments will be fact specific and case by case, and I don't have my own analysis of whether the UK measure, whatever it ends up being, will be found discriminatory in the same way that the French tax is. But I do think that there will be increasing convergence between the trade silo and the tax silo, and I think there will be a lot of work for the tax lawyers who are savvy in digital, or the trade lawyers who understand tax in the coming years.
Nigel, do you want to chime in there?
No, I mean, Sam does a good job in covering it there. It's a challenge that obviously overlaps in that there's a century of international tax law that has worked to prevent double taxation by requiring a nexus before companies are subject to a corporate tax. Also the fact that, like, the French tax and others are taxing companies' sales rather than profits is a departure from long-standing tax principles. Meanwhile, we obviously have trade agreements which have restricted the right to discriminate against foreign producer, and the French tax and others, by design, target nearly exclusively American digital companies. And so it's really a huge, another point of uncertainty about the governance of the global digital economy, about how those two sort of merging worlds are dealt with as they've now come together.
Thank you. Sabina, here's a question for you. This person asks, I'm not sure I understand this phrasing, but they want to know the knock-on effects of today's decision. On one hand, the EU has provided GDPR equivalents to Japan, and the US has a digital agreement with Japan, which allows for data transfer. Hence, can there be a backdoor for EU data to end up in the United States?
So that is a very good question. What I would say to start with is that the whole system of EU adequacy decisions is that they are granted, but they can be taken away. So the way they actually work is not that you've kind of given an approval to a data protection system and you said, okay, it's adequate, and then, you know, it's valid forever. So, you know, the Commission can withdraw that adequacy decision for any country it has granted an adequacy, a positive adequacy assessment to. So I think that, in a way, kind of protects, if you want, you know, to a certain extent, kind of protects your citizens' data in a way that every country, when they have to think about what they are doing, what they are agreeing to, and what kind of protections they put in place, they also have to assess the possibility of losing that adequacy decision with the EU. And I think there was I'm not super familiar with the case, but I think there was a recent discussion actually on this in Canada, who has only a partial adequacy decision with the EU for commercial actors, but there is something that they were willing to, like they're looking to kind of implement or agree that would have affected that adequacy decision. So it's a bit of a balancing act where basically countries have to, who have an adequacy decision, have to consider multiple factors when they decide to go one way or another, and how that affects the possibility of losing it. And I think this is why, in a way, this is so complicated for the UK, because there are other countries who have agreed adequacy decisions, there are countries who don't have them. So in a way, this is so important to the UK because of how entrenched the data flows are with the European Union and how those developed over the decades. So it's a lot more significant an issue for us than for others. But I think that to answer your question is just the basic fact that adequacy can be taken away.
Susan, if I can just chime in one thing. I think the decision today in terms of flow-on effects also highlights the underlying risk of the EU's approach to using adequacy as its primary vehicle. Because if I'm not mistaken, I think there's 6 or 7 adequacy determinations that are currently up for review, and it's essentially a live agreement. And now they need to now review these existing agreements in light of this decision. And so this question about rules and regulations around government access to data will now appear in all of these existing adequacy determinations, which are now put into question. So there's no certainty that even if you do have one, that you'll keep it, because the EU keeps on shifting the bar. And that bar relative to where so many other countries are at in their terms of stage of development and approach to these issues is a long way away. So it's a hugely complicated, uncertain process that they continue to build. Okay,
Thank you very much for that. Just the UK, this is for Sabina, whoever would like to answer this, but do you see the UK's advancement of its unilateral digital services tax affecting negotiations? And just thinking about, the United States approach to countries taking the tax has been to target them with tariffs in other sectors. I've thought a lot and noted that in no trade agreement can we find any discussion of how do you respond to trade barriers in the digital realm? What's the appropriate strategy? So can you guys comment on that? What do you do if another country censors? Do you put tariffs on them? It just seems to me the inconsistency has not been noted.
Yeah, so I agree. I think, it's a very complex picture right now. And I think, Nigel pointed to it a bit earlier as well, and Sam. What I would say is that there is an ongoing negotiation of the OECD, looking at specifically these issues of how do you tax tech companies operate in multiple jurisdictions. And those negotiations are currently on a bit of a pause. I would put that on the US election more than anything else. But I think all we are seeing with all the various digital services taxes and the kind of tariff retaliation will ultimately just have to bring everyone back to the negotiating table. So they're so kind of damaging in the long term for not only like as a mini trade war, if you want, but for bilateral relations of all kinds, that ultimately there will have to be a kind of multilateral solution to these issues. So I would say that. But on the specifics of the UK-US negotiation, I think the US has made it very clear that it doesn't like the digital services tax. We'll see how the investigation evolves and what it comes up with. We've seen the US tech sector being very vocal that, they would like within this trade agreement, they would like to see a trade agreement only if that DSD is withdrawn. So we've seen very, very strong position taken by the US in this negotiation when it comes to kind of a separate issue, but related issue of the DSD. So we'll see how how the UK kind of responds to that in due course, but definitely a major issue in this, in the UK-US negotiation.
Can I ask everybody to stay for 5 more minutes because we have a ton more questions? Is that okay for you, Sam?
Fine with me, yeah.
All right, so here's an interesting question. Can you comment on the idea of a data dividend and how that relates to digital cross-border trade?
I think if I can take a stab at it, I think it's a misguided focus in terms of trying to better understand the nature of how data is used and how countries can develop their own digital economies. And it touches obviously on issues we've already discussed, and it's looking at how do you, and it's sort of a result of, I suppose, the debate around how do you firstly domestically update tax arrangements to reflect the nature of the domestic digital economy, and then B, how do you govern international digital trade, and how does that fall within tariff and tax regimes. And I just think though that in sort of conflating some of these and other issues together in terms of looking at data, we're really raising the prospect of sort of an overarching framework governing how firms use data in a way that sort of is super intrusive and is likely just going to slow down our ability to use it to learn and do things better. But I get that it's I suppose a genuine reflection of frustration and misunderstandings around how data and digital technologies are being developed and deployed around the world.
Up. Anyone else want to take that up?
Sorry, Susan, you're on mute. Susan, if you just asked us a question, you were muted, and I think we missed it. Still muted. Now we can hear you.
Okay. My computer seems not to be working well. Okay, building on that question, can you point to any successful examples of digital trade rules adopted or set up in developing countries?
Yep.
Yeah, absolutely.
Yeah, go for it, Sam.
Well, I mean, you may have more to add, Nigel, but the ones that come to mind first are the TPP digital trade rules, which are very high standard. The TPP 11 includes Mexico, Peru, Malaysia, Vietnam. You can define developing as you wish, but certainly some of those countries would qualify.
Yeah, I'd also add, I think it's reflective of the fact that there are a growing group of policymakers in developing countries that recognise that if they want to maximise the benefits of data and digital technologies, they need to be working with their trade partners far earlier. And besides DEPA, the group that gives me hope that this a global rules-based framework is possible is the Pacific Alliance, Mexico, Colombia, Peru, and Chile, who have been, to their credit, enormous credit, been working to build, integrate their regulatory and trade arrangements for years now. And they do this, we've engaged with them frequently on this, and they really do see the need for them to build scale through putting their markets together. I think there's also sort of an increasing recognition in Brazil that this is the path that they now need to be taking. Brazil agreed to CPTPP type data flow rules in its updated FTA with Chile. Brazil's also a major proactive player in negotiations at the WTO. And then on top of that, you have obviously various discussions going on in Southeast Asia and ASEAN about how to manage data flows and digital trade there. And so I think there are a number of countries that are coming up as models for developing countries to follow as to how to embrace the opportunity of digital trade in working with their trade partners.
Sabina?
I wouldn't have much to add to what they've already said. I think that's perfectly well covered now.
Okay. How can the soft approaches that you mentioned, like MOUs and other types of agreements, be used to complement trade rules?
Sure, but in a number of ways. One way that has probably gotten the most attention is that these MOUs provide greater certainty and confidence between regulatory agencies in different trading partners to know that their regulatory concerns are addressed and still possible within the context of binding rules and trade agreements. So I definitely think that that's one part of it, in that it provides regulatory certainty. It also provides regulatory connections between different data privacy protectors, cybersecurity agencies, and whatnot there, that as they move through their domestic sort of law and rulemaking process, they can work with their partners, share information, best practices in that way. I think what we will now see the UK follow, that deeper sets for the countries in Southeast Asia, is going one step further in doing joint studies on issues of mutual concern in the digital economy, in terms of connecting different firms and sectors of the digital economy so that they can collaborate sooner and quicker and better, so that they can leverage their respective comparative advantages and competitive advantages to go global.
Anyone else want to answer this?
I can jump in. I think this kind of provide, as Nigel said, we provide a bit of confidence for national regulatory authorities that, even within binding rules, you can actually have room for that conversation. Regulatory cooperation trade agreements has a bit of a nasty kind of line to it, if you want, since TTIP and even earlier. That kind of, especially for like civil society and for kind of European civil society specifically, that, you kind of give away regulatory power to some foreign entity. And that discussion is picking up pace in the UK as well. We've seen that in, for instance, in intermediate liability discussions. If we have USMCA provisions, how are we going to be able to kind of do any kind of regulation on disinformation or hate speech or other things? So we've seen that picking up space. So I think having the mechanisms that gives confidence to the regulatory authorities, but also the public at large, that these issues will be addressed, and they will be addressed on a kind of constant basis, is super important. And another thing I would say is about, the kind of issues we are talking about. It's emerging technologies, is technologies that are moving very, very fast. So having that kind of forum where regulatory authorities and policymakers can actually communicate with each other when they move forward on new regulation on these issues can actually help kind of reduce all the barriers that we are seeing kind of popping up because of the way countries approach regulation to emerging tech, without in any way taking away the domestic remit of regulating whichever way you want, but creating that framework where countries can have that conversation and like-minded partners can have that conversation, I think is very important.
Sam, do you want to add anything?
I think Sabina covered that question pretty well.
Okay, let me ask you guys one more question that I didn't say in advance, but arises out of these questions, which is, how should trade agreements and foreign assistance be, how can policymakers do a better job of improving governance in the developing world related to data? So for example, Midyar had for about 2 years a program trying to improve personal data protection throughout Africa. And they helped many of these states, but they don't do that anymore. It's 2 years. We know very little about enforcement and what effective enforcement of personal data protection looks like, let alone for open public data. So what should a government such as the United States or the UK or Canada be doing to link trade and agreements and facilitation? Sam, shall we start with you?
Sure. Yeah, I mean, I think it's a hugely important connection. And that's true both for the sort of trade and commercial objectives of the United States, Canada, UK, EU, and others, as well as for the development objectives of those countries. So, in the development assistance that USAID or DFID in the UK provides to the developing world, there is increasingly the kind of aid that is provided, the kind of services that are provided, like everything else in the world, is dependent on the underlying ICT networks that are supplying internet service to governments and to people and to corporations. And so if you want that aid to be supplied in a way that protects the privacy of the individual people in the beneficiary country and protects the security of government information or corporate information in that country, I think it's of increasing importance that aid come along with both technical assistance as well as regulatory support to help put in place the governmental and technical mechanisms to ensure that aid can be supplied in a secure and private way. And I think that kind of support, as I said, also supports the trade and commercial objectives of the donor countries as well. The EU, US, Canada, UK, their exporting interests are served when the privacy of people in the beneficiary country is protected, and when the cybersecurity of those governments and corporations and people is assured. So I think that it's very much a two-way street and a hugely important connection.
Sabina, do you want to add anything? Thank you, Sam.
I'll just briefly say, so I think it's important to kind of focus on the role of technology in achieving the sustainable goals, and how, basically how do you add that in your trade policy in such a way that you're kind of walking the walk as well, walking the talk. So the Department of International Development in the UK had a very good kind of program for it for 2018 to 2020. I think it was called the Digital Strategy program, and it focused specifically on this transition to the digital economy, and kind of linking your aid to provisions related to either transition to the digital economy or participation in global value chains, and how do you kind of assist the countries that through your development aid in a way that kind of reduces that digital divide and kind of connects countries better to the whole discussions that we kind of have around here on the principles of digital trade, and how do you kind of achieve that without kind of leaving half of the world behind it. So I think that's potentially a model to look at, and we definitely support this link of how do you actually do digital trade provisions, and the fact that the UK vision is so much focused on digital trade, while also making sure that the related policy areas, not only aid, but environment and other things, how do you add those to the package in such a way that you're coherent basically with your policy.
Nigel?
Yeah, no, a great question, and I think it will form a large and growing part of the path we all take in the future, in terms of, again, linking digital trade and with other related issues, in this case, digital development. And it's been good to see DFID, also USAID and other aid agencies increasingly focus specifically on digital governance issues. I've been involved with some of these in the Asia Pacific. USAID has just expanded this type of cooperation now, which is great to see, but it still hasn't reached that sort of integrated status with USTR. Also, these bilateral efforts are hugely constructive, but they come in a broader context where the World Bank and others have done far too little as it relates to hard technology in terms of infrastructure, but also the soft governance policy side of this. If we stand any chance to connect the remaining half of the world's population that is not yet digitally connected, and to improve their standards of living to achieve the sustainable development goals, a lot more needs to be done to leverage data and digital technologies. And that's in helping connect, obviously, the remaining half, but then also the supporting governance infrastructure. The World Bank is in the process of developing it's in the process of designing its World Development Report for next year, which will focus on data. And I really hope there's a lot more emphasis and resources that will be directed to this governance part of the equation, because there's such a huge amount of work to be done there to build up the domestic rules and regulations and capacity and understanding around these issues.
Thank you so much. Thank you, audience, for attending this, and thank you, our very thoughtful speakers. And speaking of Schrems 2, on the 21st with Georgetown Law, we'll be co-sponsoring an event on that topic, and we hope you'll join us for that, and we'll send out the invitation soon. And then we're going on hiatus for a while, but we'll pick up again with Xiang Fang of the World Economic Forum on 3D printing and trade. So we'll get that out to you guys sometime soon. But thank you so much, these smart, helpful, really thoughtful comments. Thank you guys, and thank you, audience, and everybody have a great day. Bye-bye.
Thank you.
Thanks, Susan.
Thanks, Susan. See you, Sam.
Thanks all.